The apartment complex sits half a mile off Washtenaw Avenue, a stretch of two-story buildings populated mostly by graduate students and young couples priced out of Ann Arbor. The air on the morning of March 10, 2026, hangs at 31 degrees, frost on the windshields. A maintenance worker named Luis Ortega is already awake, hauling a salt bucket toward the leasing office, when he notices the 3 Tahoes idling with their headlights off. He stops walking. He watches. The officers move in a practiced wedge, 2 front, 2 flanking, 2 rear. They approach the exterior stairwell of Building C and climb to the 2nd floor. The lead officer, a deportation officer out of the Detroit field office named Brendan Hollis, knocks 3 times in measured intervals. He identifies himself as police. Inside Unit 3B, Arman Reza opens the door in a gray hoodie and sweatpants, expecting a neighbor about a leaking radiator. He is told to step outside. He is told he is being detained on an administrative warrant under Section 236 of the Immigration and Nationality Act. He asks if he can put on shoes. Hollis allows it. Reza is permitted 90 seconds inside the apartment, supervised. He grabs sneakers, a wallet, and a thin folder of paperwork from his desk.
The folder contains a copy of his I-20, the form that certifies his enrollment at Clearly University. He believes, wrongly, as it turns out, that this paperwork will end the encounter at the curb. By 5:14 a.m., he is in the back of the lead Tahoe. By 5:42 a.m., the convoy is southbound on US 23. The destination is the Calhoun County Correctional Facility in Battle Creek, a county jail that contracts roughly 250 beds to U.S. Immigration and Customs Enforcement under an intergovernmental service agreement. Reza will be detainee number 2026-0311-A-114 by lunchtime. He does not yet know that his CVIS record, the Student and Exchange Visitor Information System file that tracks every international student in the United States, was terminated 4 days earlier. He does not know who terminated it or why. He does not know that the termination is the legal pretext officers are carrying in their folders. To him, he is still a student. He has a thesis defense scheduled for April. Clearly, University is a private research institution of about 4,800 students, located in a small Michigan town tucked between Ann Arbor and Jackson. Its international student population hovers near 600. Roughly 40 of those students hold F1 visas tied to engineering and computer science programs. Arman Reza is one of them. He arrived from Tehran in August 2022 on a fully funded research assistantship in mechanical engineering. His advisor, Professor Diane Karstens, will later describe him in court documents as the most reliable graduate student I have supervised in 19 years. That reliability does not matter at 5:14 a.m. What matters at 5:14 a.m. is the CVIS termination code. Otherwise failing to maintain status. 9 words. No further explanation in the file. The code was entered remotely on March 6th by a system administrator working under a Department of State directive that, in the spring of 2026, sweeps through hundreds of student records across the country. Some terminations are tied to minor traffic citations. Others are tied to social media posts. A handful, Reza's among them, appear tied to nothing the student is aware of having done. By the time the Tahoe crosses into Jackson County, his attorney does not yet exist as his attorney. She is asleep in a townhouse in Royal Oak. Her name is Priya Sundaram, a 39-year-old immigration lawyer with a solo practice and a caseload that has tripled since January. She will receive the first phone call about Reza at 7:11 a.m. from his roommate, a doctoral candidate in chemistry named Wesley Chen. Wesley's voice on the call is flat. He has done this before, not for himself, but for a cousin in 2019. He knows the script. He gives Sundaram the apartment address, the time of detention, the description of the vehicles, and the badge number Hollis recited on the way out. Sundaram writes it all down on a yellow legal pad. By 7:23 a.m., she has opened a G28 form on her laptop and begun drafting a notice of representation. She does not yet know where Reza is being held. This is the first obstacle, and it is a familiar one.
ICE detention transfers in the first 48 hours often outpace the paperwork that follows them. A detainee picked up in Ypsilanti can be processed in Battle Creek by noon, transferred to a staging facility in Ohio by sundown, and routed to a long-term contract bed in Louisiana before counsel ever locates the file. Sundaram has watched it happen twice last year. So she does what experienced immigration attorneys do. She calls everyone at once. The Detroit ERO field office, the ICE online detainee locator system, the Calhoun County Jail directly, the university's International Student Services Office, where the director, a soft-spoken administrator named Margaret Oyalaran, has just arrived at her desk and is reading an email from Wesley Chen with the subject line, Urgent, Armin. By 9:40 a.m., Sundaram confirms Reza is in Battle Creek. By 10:15 a.m., she has filed her G28 and requested a custody redetermination hearing under 8 CFR Section 1003.19. The clock she is fighting is not days, it is hours. In immigration detention, momentum belongs to whoever moves first. Inside the Calhoun County facility, Reza is processed into a dormitory-style housing unit on the second floor. The unit holds 64 men. The bunks are stainless steel with thin blue mattresses. He is issued a navy jumpsuit, rubber sandals, a toothbrush sealed in plastic, and a laminated card with the phone code for the facility's contracted communications provider. Calls are billed at 21 cents per minute. His commissary account starts at 0. He sleeps in the top bunk over a 44-year-old Honduran man named Edgar, who has been at Calhoun for 9 weeks awaiting transfer. The first night, Reza does not sleep at all. Back at Clearly University, the story moves at the speed of a campus discovering something has happened to one of its own. Professor Karstens learns of the detention at 11 a.m. when a panicked teaching assistant interrupts her office hours. By noon, she has emailed the dean of the College of Engineering. By 2 p.m., the dean has emailed the provost. By 4:30 p.m., the provost is on a conference call with general counsel and the director of International Student Services. By 7 p.m., a faculty letter is being drafted. Think about how fast that is. Most institutions take weeks to mobilize. Clearly University takes 9 hours. The faculty letter, when finalized on March 11th, runs 4 pages. It is signed by 137 professors. It attests to Reza's enrollment, his research contributions, and his standing in the department. It is addressed to the immigration judge assigned to his case, the Honorable Marcus Whitfield of the Detroit Immigration Court, an appointee with 11 years on the bench and a reputation among the bar for reading every page submitted to him. The letter is Exhibit B in Sundaram's bond motion. Exhibit A is the I-20. Exhibit C is a sworn declaration from Margaret Oyalaran, stating that the university had received no notice, none, of any CVIS termination prior to March 10th, and that Reza's enrollment was active and in good standing as of the morning he was detained. This is the heart of the legal fight. If the CVIS termination was procedurally defective, the pretext for detention collapses. If the pretext collapses, the bond argument writes itself. But pretext is not the same as outcome. ICE attorneys in the Detroit field office can argue that the agency relied on the SEVIS record in good faith. They can argue that Reza is, as of March 10th, technically out of status, regardless of how the termination occurred. They can argue flight risk,
a single Iranian national, no spouse, no children, a research field that includes work funded in part by a federal grant. They can argue national security implications under boilerplate language that judges hear sometimes 3 times a week. Sundaram knows all of this. She prepares for all of it. The bond hearing is scheduled for March 27th, 17 days after the arrest. In those 17 days, the case grows. The Clearly University Graduate Student Association raises $14,200 in a single weekend for legal fees and a potential bond. The Michigan chapter of the American Immigration Lawyers Association assigns a second attorney, a former INS trial attorney named Robert Manning, to consult on the case pro bono.
A local reporter for the Ann Arbor News, Caitlin Voss, files a public records request for the SEVIS termination directive. Her request is denied. She files an appeal. The appeal is denied. She writes the story anyway. Inside Calhoun, Reza loses 11 pounds. He attends his first detention orientation on day 3. He learns that the facility's grievance process runs through paper forms delivered to a slot near the day room television. He learns that the law library, such as it is, consists of a single computer with a clipped keyboard and a printed list of pro bono attorneys, most of whose phone numbers are out of date. He learns that the man in the bunk across from him, a Salvadoran day laborer named Rafael, has been held for 14 months without a bond hearing. Reza will get his hearing in 2 weeks. Rafael may never get one. This is the gap that defines the system. Not cruelty in any single decision. The math of who gets noticed. The week before the hearing, Sundaram files a 47-page bond motion supported by 23 exhibits. Affidavits from Karstens, Oyalaran, the department chair, 2 former roommates, a landlord, and Reza's pastor, a Presbyterian minister in Ypsilanti who has known him for 2 years through a community ESL program. Bank records, lease records, a letter from the Iranian American Cultural Society of Greater Detroit offering to post a portion of any bond. She also files something more aggressive. A motion to terminate proceedings, arguing that the underlying SEVIS termination was issued without notice to the student or the institution, in violation of 8 CFR Section 214.2 F8, and that the resulting NTA, the notice to appear, is therefore legally defective. The motion to terminate is a long shot. Sundaram knows this. She files it anyway, because losing a long-shot motion can still shape the bond argument. The ICE attorney assigned to oppose her is a man named Gregory Halmstad, a 12-year veteran of the Office of the Principal Legal Advisor. Halmstad is methodical. He does not bluff. His brief, filed on March 24th, runs 31 pages and leans hard on flight risk arguments. He attaches a copy of Reza's I-94 entry record, his research publication list. 3 of the 7 papers involve computational fluid dynamics with potential dual-use applications, and a memorandum from an unnamed analyst flagging Reza's name in connection with a 2023 academic conference held in Doha. The conference was open to the public. Reza presented a paper on heat exchanger efficiency. He was 23 years old. The memorandum does not allege wrongdoing. It alleges proximity. March 27th arrives gray and warm. The Detroit Immigration Court occupies the 7th floor of the McNamara Federal Building on Michigan Avenue. The hearing room is small, fewer than 30 seats. By 8:30 a.m., the gallery is full. Professor Karstens is there in a navy blazer. Margaret Oyalaran is there with a folder of additional documents. Wesley Chen is there with 3 other graduate students. Reza's parents are in Tehran, watching the time difference, waiting on a phone call that will come hours later. Reza appears by video link from Calhoun. The connection is poor. His jumpsuit is wrinkled. His beard has grown in. Judge Whitfield calls the case at 9:14 a.m. What follows is not television drama. It is procedural. Sundaram speaks first, walking through the bond factors: ties to the community, length of residence, lack of criminal history, family in Iran but financial roots in Michigan, and the central evidentiary question of whether the SEVIS termination was lawfully issued. Halmstad speaks second, hitting the flight risk argument hard, referencing the Doha conference twice, requesting denial of bond or, in the alternative, bond set at no less than $40,000. Whitfield asks 4 questions in 63 minutes. The first is to Sundaram. When did the university first learn of the SEVIS termination? Answer: March 10th, after the arrest. The second is to Halmstad. Does the government have any evidence that Mr. Reza was personally notified of any change in his status prior to March 10th? Answer, after a pause: No, Your Honor. The third is to Sundaram. Is the university prepared to confirm continued enrollment if bond is granted? Answer: Yes, in writing, signed by the provost. The fourth is to Halmstad. Does the government allege any criminal conduct? Answer: No, Your Honor. Whitfield recesses at 10:24 a.m. He returns at 11:08 a.m. He does not rule on the motion to terminate. He sets it for further briefing. On the bond motion, he rules from the bench. Bond is granted. The amount is $5,000. In the gallery, no one moves. Sundaram exhales. Karstens places a hand over her mouth. The graduate students look at each other. On the video link, Reza appears not to understand at first. The audio lags, and then he understands, and he closes his eyes. Halmstad requests an automatic stay pending DHS review. Whitfield denies it. The order is effective immediately. The case turns here. It is not the end. It is a hinge. By 4:30 p.m., the $5,000 has been posted at the Detroit ICE field office, drawn from the Graduate Student Association Fund and a $1,000 contribution from Karstens personally. By 9:50 p.m., Reza is released from Calhoun in the same gray hoodie he was wearing on March 10th. Wesley Chen drives down to pick him up. They stop at a gas station near Marshall. Reza buys a coffee. It is the first one he has finished in 17 days. He sleeps in his own bed that night. He sleeps for 14 hours. The case is not over. The motion to terminate is briefed through April and May. On June 4th, Judge Whitfield issues a 22-page written decision granting the motion in part. He finds that the SEVIS termination was issued without adequate notice and that the resulting NTA cannot stand on its current evidentiary record. He does not order the SEVIS record reinstated. That authority belongs to the Department of State, but he terminates the removal proceedings without prejudice. DHS files a notice of appeal on June 18th. The appeal is pending before the Board of Immigration Appeals as of this recording. In the meantime, the university petitions for reinstatement of Reza's F1 status through USCIS. The petition is supported by 2,300 pages of documentation. Reza files his I-539 on June 9th. The processing time, by current USCIS estimates, runs 8 to 14 months. He cannot leave the country during that window. He cannot work outside of his on-campus assistantship. He defends his thesis on July 22nd, a date pushed back from April. He passes. Karstens cries. So does he. The cost of the case, by Sundaram's final invoice, runs to $38,400. The Graduate Student Association covers $19,000. The university's Emergency Student Crisis Fund covers $12,000.
Sundaram writes off the remaining $7,400. Reza's CVIS record, as of this date, remains in terminated status. The June 4th court ruling does not unilaterally restore it. The reinstatement petition remains pending.
He is, in legal terms, in a kind of suspended animation. Free, enrolled, defended, ungraduated in the formal sense, and still waiting on a single administrative action in a building in Washington he has never visited. He is also still here. At 4:47 a.m. on March 10th, 3 unmarked Tahoes pulled into a parking lot in Ypsilanti, expecting to remove him from the country. 17 days later, a judge in Detroit said the paperwork did not support that outcome. 86 days after the arrest, a written opinion said the paperwork never had. The system worked exactly as designed for Armin Reza. That is worth sitting with, because for the man in the bunk across from him, the Salvadoran day laborer named Rafael, who had been waiting 14 months for a hearing, the same system was working exactly as designed too. The difference was not the law. The difference was 137 signatures on a faculty letter, a solo practitioner who answered her phone at 7:11 a.m., and a graduate student association that raised $14,200 in 48 hours. There are 600 international students at Clearly University. There are roughly 1.1 million international students in the United States. As of June 2026, the Department of State has terminated CVIS records for an estimated 4,700 of them under the directive that swept up Reza. Of those, approximately 1,900 have retained counsel. Of those, approximately 340 have obtained bond. The remaining numbers are harder to confirm. ICE does not publish a daily ledger. What ICE does publish is a detention population. As of the last weekly report, that population sits at 47,300 nationwide, a figure that includes Calhoun County, where Edgar from Honduras is still in the bottom bunk, and Rafael from El Salvador is still waiting for a hearing date that has not been set. Armin Reza is back at his desk in the engineering building. There is a folder on it. Inside the folder is the I-20 he grabbed from his apartment on the morning of March 10th. He keeps it there because his attorney told him to keep it there. He has not opened it in 2 months. It is still cold to the touch.